Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. I would ask our guests here in-house if you'll be so kind to check that your cell phones have been turned off. It's always appreciated. We, of course, will post today's program on the Heritage homepage following the presentation for everyone's future reference. And our internet viewers are always welcome to send questions or comments at any time, simply emailing speaker@heritage.org. Hosting our discussion today is John Malcolm. Mr. Malcolm is the Ed Gilbertson and Sherry Lindbergh Gilbertson Senior Legal Fellow, as well as the director of our Edwin Meese Center for Legal and Judicial Studies. Prior to joining Heritage, he held a variety of positions, including serving as Deputy Assistant Attorney General in the Criminal Division at the U.S. Justice Department. He was an Executive Vice President in charge of anti-piracy operations at the Motion Picture Association of America, just in time for the Academy Awards, and the General Counsel at the U.S. Commission on International Religious Freedom. Please join me in welcoming John Malcolm. John?
Thank you, John. I will introduce, by the way, our keynote speaker, who will give his remarks, and then I will introduce our panelists who we'll hear from afterwards. So next Wednesday, on March the 4th, the Supreme Court is going to hear oral argument in the case of King versus Burwell. The case deals with whether or not, under the Patient Protection and Affordable Care Act, the government can extend tax credit subsidies to people who purchase insurance through exchanges established by the federal government. We are honored to have as our keynote speaker on this very important topic the senior senator from Utah, in fact, the most senior Republican in the United States Senate, Orrin Hatch, who is currently serving his 7th term. Senator Hatch is the president pro tempore, which, by the way, places him third in line to the presidency after Vice President Biden and Speaker Boehner. He is the ranking member on the Senate Finance Committee and also serves as a member on the Judiciary Committee, the Health, Education, Labor, and Pension Committee, and the Joint Committee on Taxation. He also serves on the board of directors of the Holocaust Memorial Museum here in Washington, D.C. And given the snowy weather that we have had here recently in Washington, I thought it was appropriate to mention that in addition to being a songwriter himself, Senator Hatch was once the subject of a song by Frank Zappa entitled Orrin Hatch on Skis. Please join me in welcoming Senator Orrin Hatch.
Well, I'm honored to be with all of you here today, and I hope this will be interesting to you. And I want to thank you for inviting me to say a few words here about this very important case. King versus Burwell is a tremendously important case. It is important because it may require fundamental changes to be made to Obamacare. And it's important because of its significant implications for the role of law. From the early days of the Republic, a core component of our constitutional character has been the idea that our government is a government of laws and not of men. That means that our leaders, elected and appointed, are constrained by the words of the law in a statute, on the statute books, and in our Constitution. Government officials must follow the law, even when their personal predilections would lead them in a different direction. This prevents arbitrary decision-making and keeps executive discretion within proper bounds. The current administration, however, has engaged in a sustained assault on the rule of law. In the interest of time, I will not catalog here President Obama's long train of executive abuses. I've spoken many times on the Senate floor about the president's disturbing disregard for the separation of powers and other limits on his authority. His offenses run a gamut from releasing Guantanamo detainees without first notifying Congress, as the law requires, to claiming that congressional inaction somehow clothes him with legislative-like authority. And it's a matter of great concern to me because I have never seen in all my time in the Senate this type of attitude and this type of action by a president of the United States. And He feels it's given him something like legislative-like authority to suspend immigration laws, to arrogating to himself the power to determine when Congress is in session. This last affront was one of the most absurd and offensive positions I've ever seen taken in front of the United States Supreme Court. The President's actions in the King case are of a piece with his other executive overreaches. Let me begin with some background. Obamacare requires every person in America to buy health insurance or else pay a penalty. This is the so-called individual mandate that the Supreme Court controversially upheld 3 years ago. Most Americans receive health insurance through their employer, which pays a large part of the premium, but not all do. Many must purchase insurance on their own, according to Obamacare. To ensure that such individuals are able to comply with the individual mandate, Obamacare directs states to create health care exchanges, government-operated websites where consumers can go to compare and choose insurance plans. Obamacare also provides for subsidies for individuals who purchase insurance through these state-run exchanges. Remember that most people receive health insurance through their employer, and that their employer pays part of the premium. Individuals who purchase insurance on their own through exchanges, however, don't receive this employer subsidy, so they must generally contribute more towards the premium themselves. Obamacare provides these subsidies to these individuals to help offset the costs of insurance. And with that background, let me now turn to the legal issue in the case. As I have described, Obamacare directs states to establish health care exchanges. To be precise, the law says, quote, each state shall, not later than January 1st, 2014, establish an exchange, unquote, that meets various conditions set forth in the law, unquote, rather. But there's a wrinkle. The Constitution does not permit the federal government to order states to do things. The federal government and the states are co-equal branches of government, co-equal sovereigns. The federal government cannot command the states to do something more than one state can command another state to do something. This is called the anti-commandeering principle and is well established in Supreme Court case law. What the federal government can do, however, is incentivize states to act, and that's precisely what Congress attempts to do with Obamacare, although, as I'll explain later, in my view, Congress has attempted and still runs afoul of the Constitution. Here's how the incentive works. Another provision of Obamacare, the one at the heart of this case, conditions the aforementioned subsidies on an individual's enrollment in a state-run exchange. According to this provision, a subscriber is eligible for a subsidy for each month she is covered by a plan that she, quote, enrolled in through an exchange established by the state, unquote. The text of this provision could not be more clear. If an individual enrolls in a plan through an exchange established by a state, then she gets a subsidy. If she enrolls in any other plan, no subsidy. The incentive for states to act could not be more clear. If a state fails to establish an exchange, its citizens lose out on millions, perhaps even billions of dollars in subsidies. Obamacare's proponents quite reasonably thought this would lead states to set up exchanges and would thus accomplish the same result, creation of state-run exchanges that Congress could not achieve through direct command. Congress also recognized, however, that some states might not take the deal. Thus, it provided a backstop. In another provision of Obamacare, Congress instructed that if a state does not set up an exchange by the January 2014 deadline, the Department of Health and Human Services shall, quote, establish and operate such exchange within the state, unquote. Crucially, however, Congress did not similarly provide that subsidies would be available to subscribers enrolled through a federally established exchange. And the reason is obvious. If subsidies were available under both state and federal exchanges, states wouldn't have incentives to create their own exchanges, to expend time and resources setting up an online insurance marketplace, because the subsidies would come either way. Fewer states would create exchanges, meaning the federal government would have to step in and create more exchanges on its own. The restriction of subsidies to state-established exchanges was thus a key element of Obamacare's entire cooperative federalism scheme. Without this restriction, the end result would have been a federally run healthcare market, a result unacceptable to several key Obamacare supporters, including Senator Ben Nelson of Nebraska, whose vote was essential to passage of Obamacare. Now we come to President Obama's act of overreach. Notwithstanding the unmistakably clear text of the statute, which limits subsidies to plans purchased through state-established exchanges, and notwithstanding that this limitation was absolutely fundamental to accomplishing Congress's purpose of incentivizing states to establish exchanges, the president decided that he would also offer subsidies for plans purchased through federally established exchanges. President Obama's open defiance of clear statutory text and utter disregard for the balance Congress struck is an affront to the separation of powers and to the rule of law. The president and his enablers argue that subsidies for federally enrolled plans are necessary to accomplish Obamacare's overall purpose of reducing costs and improving health care access. Without subsidies to individuals in the 34 states, without state-run exchanges, the president argues this: residents of these states will be hit with higher costs and unaffordable health care. The law must be rewritten, he says, to avoid the consequences the law itself imposes. Laying aside the fact that the Constitution gives Congress, not the President, the power to amend laws, the President's argument is completely circuitous. The reason 34 states could afford not to establish exchanges is because the President said he was going to pay subsidies regardless of whether a state establishes an exchange. Why would a state go to the trouble and expense of creating an exchange if the end result is the same? Indeed, in these difficult times of tight state budgets, not creating an exchange might be the fiscally responsible decision. The president also grasped at exceedingly thin textual straws, because the backstop provision I described above instructs that if a state does not establish an exchange, HHS shall step in and establish, quote, such exchange, unquote, itself. The president says this means that federal exchanges are state exchanges. Right is left and up is down, or maybe the president is simply unmasking his wish that all federal-state barriers be diminished, or demolished is a better word. Now, before you try to wrap your head around the president's X equals not X argument, let me return to the real provision in dispute in King, the one that defines eligibility for subsidies. This provision says, again, that an individual is eligible for each month that she is covered by a plan that she, quote, enrolled in through an exchange, I'll underline this, established by the state, unquote. An exchange established by the federal government is by definition not an exchange established by the state, regardless of whether the federal exchange is a backstop or not. And it gets even worse for the president because the provision additionally specifies that the state exchange must have been established, quote, under Section 1311 of the statute, unquote. Now that section sets forth the requirements for creating state-run exchanges. Nowhere does it mention federal exchanges. Rather, the conditions for creation of federal exchanges appear in a different section, Section 1321. Under no plausible reading of the text does a state exchange established under Section 1311 mean a federal exchange established under Section 1321. Lacking any credible textual basis for their position, the President and his supporters have taken instead to twisting my words and the words of other Obamacare opponents to claim that we used to agree with the President's argument. Apparently, their thinking is that if we used to agree with the President, then the Supreme Court should too. The Solicitor General has even dredged up a 5-year op-ed I wrote for the Wall Street Journal that he says supports the President's position. Of course, the op-ed does no such thing, as I shall explain. The title of the op-ed is Why the Health Care Bills Are Unconstitutional, unquote. That tells you right off the bat that the op-ed has nothing to do with King. The op-ed is about the constitutionality, or rather the unconstitutionality of Obamacare, whereas King is about the meaning of a specific provision of Obamacare. The op-ed addresses broad constitutional concerns. King involves a narrow, albeit highly important question of statutory interpretation. Different issues, different questions, different analysis. The op-ed outlines a number of reasons Obamacare is unconstitutional, including because it exceeds Congress's powers under the Commerce Clause and the Taxing and Spending Clause, and because it contravenes the General Welfare Clause by dispensing special favors to certain states. The op-ed, and you might remember Nelson and some of the other senators who were given special favors. The op-ed also explains how Obamacare violates core federalism principles, including the anti-commandeering principle by ordering states to establish state insurance exchanges. In the course of describing how Obamacare violates the anti-commandeering principle, the op-ed refers, without citation by the way, to the holding of South Dakota versus Dole. This is a 1987 Supreme Court decision. Dole said that Congress can lawfully condition federal funds to states as a means of incentivizing states to act, which is precisely what Congress attempted to do with Obamacare. The op-ed then goes on to explain why, in my view, Dole does not save Obamacare. Dole involved the payment of federal funds to states. To states. The specific law in issue in the case required states to raise their drinking age or else lose a certain percentage of federal highway funding. Requiring states to raise their drinking age in this way was constitutional, the court said, because states got something out of the bargain, money. But Obamacare subsidies don't go to state governments. They go to individuals, to their insurance providers, in the form of tax credits. Obamacare thus coerces state governments without giving them any monetary benefit in return. It foists new expenses on state governments without accompanying relief. And that is what I wrote in the op-ed establishing exchanges is, quote, not a condition for receiving federal funds, unquote, for states. The context makes clear that the op-ed is talking about states and what Obamacare requires states to do. Tax credits to individuals and to health insurance companies are a different beast. The op-ed further explains that Obamacare violates the anti-commandeering principle by providing that if a state decides it doesn't want an exchange, the federal government will go ahead and create one anyway. This is a bit like telling a child to clean his room, and then if he doesn't clean it, you're going to clean it for him. No matter how badly the child wants the room to stay the way it is, maybe he likes the way his toys are arranged, or perhaps a little clutter on the bare floor. You're going to make the room look like you think it really ought to look. That is not the way two equal partners work together. One doesn't tell the other, either you do what I want or I'll do it myself. If ordering a state to do something violates principles of federalism, then surely ordering a state to do something and promising to do it anyway if the state refuses also violates federalism. As I wrote in the op-ed, Obamacare's this is going to happen whether you like it or not approach, quote, renders states little more than subdivisions of the federal government, unquote. Now, one can debate the merits of the op-ed's constitutional argument, but there is no excuse for twisting my words and imputing to me positions I have never held, not then, not now. Other Obamacare proponents have dug up old speeches of mine, decrying the law's costs and inefficiencies. One writer has even made the perplexing claim that by arguing that Obamacare would lead to higher taxes, I was somehow endorsing the view that subsidies would be available on federal exchanges. Of course, I never suggested any such thing. I merely made the common sense point that as Obamacare causes insurance premiums to rise, increasing numbers of employers will drop coverage, forcing more and more Americans onto exchanges. And because Obamacare provides subsidies to subscribers who obtain insurance through state-run exchanges, we're talking millions of people here, these costs will increasingly be passed on to taxpayers. To the extent this argument assumes that most subscribers who obtain insurance through exchanges will receive subsidies, this is because at the time it was widely expected that most states would set up exchanges. As I have explained, the reason most states ultimately could choose not to establish exchanges would be because the president decided he was going to provide subsidies on federal exchanges too, thus eliminating the incentive for states to create their own exchanges. If I'm guilty of anything, it's not changing my position. It's expecting that the president would follow the law. And that's what ultimately is at stake in King versus Burwell. Is the president bound to the law, or can he rewrite simply ignore provisions he doesn't like in order to further his political agenda? Advocates of the president's position would have us believe that statutes are infinitely malleable. Up can mean down, right can mean left, established by a state can mean not established by a state. What matters to them is advancing some vague notion of statutory purpose, regardless of what the statute actually says, that coheres with the president's left-wing agenda. Those of us on the other side, however, insist that text matters. Words matter. What the statute says is what matters, because at the end of the day, the words in our statutes and in our Constitution are what bind our leaders and what prevent them from doing whatever they want to. Fidelity to text is the foundation of the rule of law. Ultimately, I believe the Supreme Court is going to side with us. Assuming that's the case, the question becomes, what do we do next? Most of the 8 million people who purchased insurance through the federal exchange last year did so based on the administration's promise that subsidies would be available. Obamacare has already inflicted a lot of damage on our nation's health care system, harming patients, consumers, and employers alike. I don't think we can stand by and simply let the shortcomings of the law harm millions more. We need to help the people who will be hurt by losing their subsidies because of Obamacare's broken promises. This means providing a reasonable and responsible transition for those who may lose their subsidies while Congress works to repeal and replace Obamacare once and for all. And that's what we have to do, repeal and replace Obamacare. That's the only permanent solution to this and a host of other problems. We need to take the federal government out of the equation and put individuals back in charge of their own health care decisions. We also need to empower states where we can. And I have already laid out some long-term reform ideas along these lines. Of course, we all know to achieve these goals, we need a Republican in the White House in addition to Republican control of Congress. Still, these remain our ultimate goals on health care reform. In the coming days, I'll release details on a short-term solution for those Americans that may be affected by the decision in King, should it go the way I think it should go. That solution will address immediate concerns and set the stage for a more permanent fix in the future. I will continue to work with my colleagues on both sides of Capitol Hill on this issue. Now, the American people deserve a health care law that works and a president who will follow the law. The former we can get started on now. The latter, well, we have 2 years till 2017. And I hope that gives you some idea of why I think the Burwell case, the King case, ought to be reversed. I hope this helps. Thanks so much.
Thank you, Senator, for those remarks. We will now hear from a couple of panelists. We will first hear from Professor Jonathan Adler, who's to my immediate left. Professor Adler is the Johann Verhey Memorial Professor of Law and the Director of the Center for Business Law and Regulation at Case Western Reserve University School of Law, where he teaches environmental, administrative, and constitutional law. Prior to joining the faculty of Case Western, Professor Adler clerked for Judge David Sentel of the D.C. Circuit, and he directed the Environmental Studies program at the Competitive Enterprise Institute, a free market research and advocacy group here in Washington, D.C. Professor Adler is the author or editor of 5 books and over a dozen chapters in other books. His articles appear in law reviews and periodicals throughout the country, and he's testified a dozen times before Congress. Professor Adler has received numerous awards, including the Paul M. Bator Award for Excellence in Teaching, Scholarship, and Commitment to Students. He's also a senior fellow at the Property and Environment Research Center and a member of the Board of Directors of the Foundation for Research on Economics and the Environment, and he serves on the advisory board of several other organizations. He's a regular blogger on the influential Volokh conspiracy and a frequent legal commentator on radio, television, and the press. Following Professor Adler's remark, we will hear from my colleague Ed Hesselmeyer. Ed is a senior research fellow in the Center for Health Policy Studies, which is part of our Institute for Family, Community, and Opportunity, where he writes frequently on healthcare policy and markets. He's also worked with both state and federal legislators developing innovative strategies for community-centered health insurance markets and consumer-focused solutions, rather than one-size-fits-all government solutions. Ed originally came to Heritage in 1987 and was Heritage's first healthcare policy analyst. However, during an 11-year hiatus from Heritage, from 1994 to 2005, Ed worked for several years as a health policy consultant, and prior to that, as the Director of Healthcare Policy in the Pfizer's Corporate Strategic Planning and Policy Division. Ed has testified numerous times before state and federal committees and is a frequent radio and television commentator, and his commentaries have also appeared in magazines, newspapers, and periodicals throughout the country. Please join me in welcome our panelists.
We start? Okay. I'll say a few things. Senator Hatch, I think, outlined the basics of the case. So let me say a few things about some of the legal issues in the case and turn it over to Ed, and hopefully we'll have time for a bunch of questions. This is a sort of case that, were it occurring in any other context, were we not talking about the Affordable Care Act, were we not talking about a president's signature domestic policy achievement, would not be a particularly controversial case. Supreme Court all the time hears cases involving statutory interpretation where maybe, with the benefit of hindsight, the text of a statute doesn't quite accomplish exactly what some folks might have wanted it to accomplish because it perhaps wasn't worded or written the precise way that, with the benefit of hindsight, one might have written it. We see the Supreme Court all the time strictly parse the words of a statute, insisting that while we must look at context, we must look at the structure of the statute, we must look at the way the statute is put together, we also must not deprive individual words or phrases with their semantic meaning. We've seen cases as recently as last term in which every justice of the court last term joined an opinion stating that practical problems with implementing a statute in line with the strict text don't justify rewriting the text or allowing the agency to redefine what words mean. Just a few weeks ago, we saw a decision from the court saying that if one statute refers to law and the other one refers to law, rule, or regulation, those two aren't the same thing. In a 7-2 decision by Chief Justice Roberts, the court distinguished that and said that it reference to something being done under law is different than something being done under law, rule, or regulation, even though a regulation may have the force of law. These are sorts of things the court does all the time, and certainly in the last few decades, we've had a Supreme Court that has cared a lot about text. This is not a court like the court of the 1970s that was happy to focus on purpose. There's actually a famous opinion from about 30 years ago in which the court said, because the legislative history is ambiguous, we'll turn to the text. That's not the way the Supreme Court does things anymore. And again, were this not the Affordable Care Act, this would be a relatively simple case. We have plain language, language that any legislative staffer or member of Congress or state legislator or agency official could understand. This isn't language in the bill like in other parts of the Affordable Care Act that are filled with cross-references and oblique references to specially defined terms. The phrase exchange established by the state is something that I'm sure everyone in this room, if they simply read, would understand precisely what it means. There's this thing called an exchange and established. Well, that's the creation of it by the state. And it's by the state. And if we're curious, the statute even defines the word state. It's like on the prior page. State is defined to be one of the 50 states or the District of Columbia. Again, in any normal context, this would be easy. It would be a 9-0 case. Now, some have argued, well, this can't mean what it means because 36 states decided not, or 34, depending on how you count, decided not to create their own exchanges, and that could create problems for the statute's implementation. But that's a change in what people expected to happen. It says nothing about the meaning of the text itself. And not only is the text clear, there's no evidence in the legislative history, in the drafting of the statute, that the text says anything other than what its drafters intended it to say. My co-author, Michael Cannon, and I are actually, probably I should say his research assistant, looked at every reference to the word exchange in the congressional record. There's not a single instance in which someone said the Senate bill provides for tax credits in federal exchanges. Yet that's the bill we have. We have clear text. We have nothing contradicting it. Elsewhere in the text, nothing contradicting it in the legislative history. No contemporaneous statement saying that the statute doesn't mean what it means. And yet the federal government comes along and says, oh no, exchange established by the state is a statutory term of art, albeit an undefined statutory term of art because it's not defined, the phrase exchange established by the state isn't defined, and state is defined to mean one of the 50 states or the District of Columbia and does not include the federal government. And the word establish is used throughout the statute quite consistently, including in the provision that tells the federal government to establish an exchange where a state does not. The government has asserted that there is a statutory term of art that actually contradicts both the consistent usage of the words in that term of art as well as the express statutory definitions of some of the terms in that statutory term of art. It's hard to take an argument like that seriously. I think what's really going on is the government is trying to kick up enough dust, create enough confusion about what is admittedly a complex and sometimes difficult to parse statute so that the court will conclude that it is sufficiently ambiguous to defer to the agency's interpretation under the Chevron doctrine. And as a matter of legal strategy, that's perfectly understandable why the government would do that. But if we actually take the Chevron doctrine, which the government is seeking to rely on seriously, we see why that is problematic. The Chevron doctrine holds that if a statute, or when a court is reviewing an agency's statutory interpretation, it has two steps to go through. First, it looks at the statute itself. And applying the traditional tools of statutory interpretation, the court asks whether Congress has addressed the precise question at issue. The question is not, is there something else in the statute that is harebrained or ambiguous or unclear, but has Congress addressed the precise question at issue? And the precise question at issue here is, where are tax credits available? And the statute tells us they are available in exchanges established by the state under Section 1311. So the statute clearly has addressed the precise question at issue. Step two of Chevron is, well, if Congress has not addressed the precise question at issue and the statute is ambiguous on that point, if the court can conclude that Congress has delegated authority to the agency to resolve that question, then the court must defer to a reasonable interpretation by the agency. But that step requires two conclusions. One, that Congress delegated this authority to the agency. So in this case, that would be the idea that Congress has delegated authority to the IRS to decide whether or not tax credits are available. And that's a conclusion that cuts against a lot of things that the government and its supporters want to argue in other contexts, which is they have to be available. Well, no, the Chevron Step 2 argument isn't that they have to. It's that it's up to the IRS. And if no state created its own exchange, that means tax credits in all 50 states would be up to the IRS, and the IRS could change its mind because Chevron allows agencies to do so. But the interpretation must also be permissible or reasonable. And that might mean deciding whether or not pollutant in a given part of the Clean Air Act includes greenhouse gases or only includes traditional pollutants. It might be whether or not the word defendant in a statute applies to just criminal defendants or criminal and civil defendants. If there's ambiguity about dusk, it might say, okay, we can decide precisely when the day ends, but it doesn't include the authority to declare that day is night. Or in this case, that established by the state is established by the federal government. That's simply not a reasonable interpretation. Again, I said this should have been a simple case. As we know with the Affordable Care Act, nothing is simple. And I think that's why we see in recent weeks many efforts by the government and its defenders not to make the legal argument, not to talk about statutory text, but to talk about the mess that Congress might have to fix if the court actually decides to stick with what Congress enacted, and how that might tarnish the Chief Justice's legacy. I've gotten lots of calls from reporters saying, well, the administration is talking about the Chief Justice's legacy. Well, if that's what they're talking about, if those are the questions or the tips they're giving to reporters, what does that say about the substance of their underlying arguments? And I think it suggests that, as the administration knows, the textual arguments are weak. If this weren't the Affordable Care Act, this would be an easy case. But it is the Affordable Care Act, so instead we have quite a political fight. And I'll stop there.
Thank you very much. That tees up nicely what I'm here to talk about, which is what kind of a mess are we talking about if the court were to find in favor of the plaintiffs here. There is an issue brief that I just did that we just published that's available outside if you want on exactly this topic. Following on Professor Adler's comments, another thing that defenders are doing is trotting out what the justices like to refer to as a parade of horribles. All sorts of horrible things will happen. This is a favorite phrase of the justices. And of course, it's an appeal to emotion, not reason, and is therefore a form of logical fallacy. But nonetheless, it is useful to look at it because if for no other reason than when the court decision comes down, if the court agrees, then Congress will have to look at what is the situation on the ground. So let me briefly go over some of these horribles. This is not an exhaustive list, simply because there are a number of others out there that are frankly attenuated or tendentious, and almost all of that is derived from the main ones that I did address. First of all, how many people would actually lose subsidies in the 34 states? And both folks on both sides of this are using the 34 number because there are 3 states where they're trying to do a state exchange, but at the moment they're relying on the feds for a lot of it, but everybody kind of assumes that however the court rules, there'll be considered state exchanges. So what we have today is the following. We know that approximately 3.8 million people last year, 2014, were subsidized in those 34 states by the end, when all the dust settled by the end of the year. So that's what we know from last year. The best estimate I can come up with, looking at the preliminary data that HHS has produced for almost all of open season for 2015, when you apply the kind of attrition rate that we saw last year, and I can think of reasons why that is reasonable. You could think of it being higher or lower, but we'll stick with that. We're looking at maybe 5.5 million affected individuals in those 34 states. Now, that could be anywhere from $1 to thousands of dollars, depending on their income. We just don't have any data that would tell us that. The other thing that we know is that a lot of this is based, or these claims are based on not only incomplete data from HHS, but also on projections and survey data, which, given all of the upheaval that this law has created, is becoming, in our view, increasingly unreliable. That's why my colleague and I have started this past year to actually dig into the market data. The problem being, of course, there's a bit of a lag because insurers file on a quarterly basis, and then the data has to be aggregated. But we're finding some very interesting things in there, and that's covered in the paper, and it links to the longer paper. Specifically, what we're finding is the following. In the first 9 months, we have the data currently available through the end of September, so 3/4 of 2014. In the first 9 months of 2014, we saw the individual market, both inside and outside the exchange, increase by a net of 5.83 million individuals. However, at the same time, employer group coverage declined by a net of 4.9 million individuals. In fact, the fall off was much larger within that among fully insured, meaning smaller and medium-sized employers that tend to just buy a group plan from an insurance company. That declined by 6.3 million, but larger self-insured employers coverage expanded by 1.4. So net, we're looking at 4.9 million decline in employer group coverage. What that leaves is for the first 9 months of 2014, we saw an increase in private insurance coverage in this country of only 892,000, 893,000 almost. That's it. It also means that 85% of the increase in individual coverage was offset by a decline in group coverage. So that gets us to another point, that when we look at the data on Medicaid, and CMS has been releasing data on Medicaid enrollments, for the same 9-month period, we're looking at an increase in Medicaid of almost 7.5 million. So how does that square up with some of the claims? Well, first off, should the court rule in favor of the plaintiffs in this case, it will not, as a practical matter, as far as we can tell, significantly impair the law's ability to expand coverage, because 90%, 89.3% of the coverage expansion we've seen so far is an expansion of Medicaid, which is, of course, not at issue in this case. It was in the last one, but it's not at issue in this case. The other thing that this indicates, along with some other pieces of information, such as the number of people who had individual market plans canceled, that is particularly important, I think, for Congress to keep in mind, is that it would appear that the vast majority of people who obtained coverage through the exchange, subsidized coverage, probably had coverage before. And so this is replacement coverage for either a individual or employer group plan that they previously had. Now, it will be interesting to see how that plays out over the coming months with the 2015 season and as we get new insurance market enrollment data for the close of 2014, to see whether that substitution effect, which is largely seems to be a shift from employer principally fully insured employer coverage into individual coverage, if that continues. But be that as it may, what it strongly suggests is that a fair number of these people used to be able to afford coverage before Obamacare made their coverage too expensive, or outright outlawed it in the case of a number of plans as being supposedly inadequate. What that suggests, I would submit for policymakers, is that going back and removing a lot of the provisions that required plans to be more expensive and thus necessitated subsidies would probably be a good place to start, a good first step going forward. And in that context, I will also promote the other issue brief that they have available out there, in which I look at what I term the key design flaws. There's a lot that's wrong with this law, but I zeroed in on what I see as, just from an operational point of view, 5 major areas where if you had done this law differently, you wouldn't have had this or many other problems. So that's kind of a guide for folks going forward. So what we're looking at is a situation where potentially maybe 5.5 million people might lose subsidies in 2015, depending on how the market settles down following open season. Of those, I would guess that a fair number, at least half probably, previously had coverage but were forced out of it or priced out of it as a result of Obamacare. Now, there's some other arguments which I get into the paper about, oh, gee, we'll have less insurer competition and insurer profits will suffer. The reality is, as we've documented in other papers by my colleagues, there has not been any significant increase in insurer competition as a result of this, so it's doubtful you would see any kind of reduction. I couldn't, I can't imagine where, maybe one or two carriers, but those are probably the few co-op carriers that are startups. Even the ones that are, there were two carriers that started in 2014 that were not federally funded, and they seem to be doing fine. Oscar Health and Long Island Jewish Hospital sponsored a plan in New York. The other point is that insurers would have major losses. I just don't see where that would be the case. Maybe one or two very small insurers. Again, maybe a couple of the co-ops would have significant losses. This is a marginal market on a marginal market. I mean, you're looking at a few million people added to a market of pre-Obamacare about 12 million. And it's about 10% of total private insurance. The other 90% is employer coverage. And when you look at virtually any insurer out there, other than a very few very small ones, this is not a large share of their business. So I just find some of these claims completely stretched. And then there are, of course, as I said, some others which are not covered in the paper that, oh my gosh, people will die if they're not covered and whatnot. Again, these are extrapolations that get increasingly tendentious and are based on the same erroneous assumptions that you actually have more people who would be affected by this ruling than would be the case. So I think just summarizing, I'll stop there, and maybe, John, we can have questions.
Great. I'll stand here so that I can see folks over on this side of the room. So we'll turn in just a moment to audience questions. I would ask for you to raise your hand to be recognized. And then the three things that I would ask are, one, that you identify yourself and your affiliation. Two, keep it short. And three, actually end it with a question mark. So with that, if anybody has any questions. And actually, let me take the moderator's privilege and ask the first question, which is one thing that people really aren't talking about in relation to this case, is that there could be an effect on the operation of both the individual mandate and the employer mandate. That's my understanding. Jonathan, I wanted to know whether you could address that a little bit.
Yeah, just very briefly, and this actually relates to how these cases are in court in the first place. The employer mandate is enforced by a penalty, or what some would call a tax, but whether we call it a tax or a penalty, that is triggered by the availability of tax credits. Basically, and I'm oversimplifying a little bit, if you're an employer that's covered by the mandate and one of your employees is eligible for a tax credit, that's what triggers your liability, assuming that the federal government's recognizing that liability, which they haven't up till now. But and so that's, if the tax credits are gone in states with federal exchanges, there is no basis for triggering the employer mandate liability in those states. And then with regard to the individual mandate, or the tax penalty that is what's left of the individual mandate, liability for that is dependent upon, and again I'm oversimplifying, the cost of insurance as it relates to your income. And it's the out-of-pocket cost. So the availability of tax credits in a given state actually exposes more individuals in that jurisdiction to the individual mandate penalty than would be exposed to it absent the tax credits. And it also shifts the incidence, because you have people that could not out-of-pocket afford the full cost of their premiums, but could afford a subsidized premium if the federal government is covering part of that with the tax credit, and then in some cases a additional cost-sharing subsidy that goes directly to the insurance company. So the incidence of both those penalties is significantly affected by the outcome of this case.
Any questions from the audience? Don't be shy. Oh, yes.
Yeah, hi, Phil Kirpin. I've got a logistical question about state exchanges. If we do see a plaintiff victory and there's a rush in some states to establish state exchanges, first, do we expect that HHS will somehow find additional grant funds despite the law's termination of that on a date certain, given all of their other creativity? And second, what protections might taxpayers have against, another disaster of the Oregon or Hawaii style where the money just disappears into a hole and there's nothing to show for it?
Well, the short answer to your last question is they don't have any protection against that. Whether it's new or existing funding. The problem that HHS has is first of all, they've expended the pre-appropriated monies that were in the law for grants to states to set up exchanges. Two, they tried to shuffle around other monies, but particularly by raiding the pre-appropriated Preventive Health Services Fund, which was also in there. But in the last couple rounds the Cromnibus this year and the Omnibus last year, Congress did a pretty good job of nailing those things down and shut. So they don't have a lot of places to go. Now, the one place I can see where they would go on this, but it would also raise a whole nother issue, is that Congress, again, because they didn't envision the federal government running the exchanges, made absolutely no provision for funding a federal exchange. There's no pre-appropriation in the law for that. And so when they wound up having to fund a federal exchange, they went to a user fee statute, a general user fee statute, and so they're charging user fees, which, by the way, if you're in a state with a federally run exchange and you need to buy insurance on an unsubsidized basis, I advise people to check e-health insurance. You may find the exact same policy for 2 or 3% less because they don't have to pay the user fee outside of the exchange that they have to pay in the exchange. Now, based on their behavior in another area, I could see them attempting to misappropriate user fees, but they would then have to raise the user fee probably to fund that. They have tried to do that in the cases involving the HHS mandate with their so-called accommodation. That's a whole other thing that I think is not legal, but that's the one place where I would think that they might try to do that.
I would just add, certainly this administration has been creative in doing lots of things under the law to affect its implementation. My favorite has usually been declaring that the law itself is a hardship, which justifies the hardship exemption under the individual mandate, which, if you parse the language of the statute, actually is probably permissible. It's ironic, but it's probably the legally the least outrageous thing that folks have been talking about. There'd be issue of funding. There'd also be the issue of whether or not HHS tries to allow states to shortcut the various requirements to create an exchange. The statute is pretty specific about some of the things states have to do for an exchange to actually be an exchange under Section 1311. My guess is that HHS would try and ease that path as much as possible. And if they cut corners, then I would think they would be liable to, or vulnerable to follow-up lawsuits by employers, by individuals who could be subjected to penalties as a result of the creation of a state exchange. But they'd have to do that because, as we know from the state experience, creating a state exchange is very difficult. And it's going to be hard for a state to do that very quickly under the way the law is written now. Congress could obviously make changes, but as it's written now, it would be hard to do that very quickly if the law itself is going to be complied with.
Yeah, I would simply add they can try to ease the path in a number of ways. Some may or may not be open to challenge. I defer on the ones that might be. I can think of a number, such as letting their vendors just basically resell, the work product probably they could get away with. But the bottom line is that, back to the question, any state that tried to do it would probably be looking at having to front pretty much all the costs to do it themselves. So there's a limited amount of help that HHS can give them with easing requirements or things like that.
Got a question down here in front.
Thank you. My name is Beverly Gossage, and we are health agents and just happen to be here this week for the National Association of Health Underwriters Conference. I can tell you that we have placed people on the exchange, assisted them with purchasing policies. The vast majority, as I have interviewed agents and said, how many of the people that you placed on the exchange were formerly uninsured? The answers come back anywhere from 1% to 10%. You were absolutely right, Ed. They are not. These are people who lost their policy or they had to change their policy. So they are saying to us, I hope this passes. I hope that the plaintiffs win, even though I'm getting a subsidy, and I hope they just let me have my old policy back at the rate I used to pay. My question is this. We were just reading yesterday that yesterday, that these cases have been flooded with recent amicus briefs. I wondered if you, one, had an opportunity to read those, and two, what is your concern about standing?
Sure. Yeah, there's 31 amicus briefs, if I recall correctly, 20 on the plaintiff's side, 31 on the government side. A lot of amicus briefs by various nonprofit groups, bunch of academic briefs. I co-authored one with Michael Cannon, who I've written a lot on this issue with. A handful of industry briefs on the side of the federal government. I think some of the briefs raise some interesting issues that aren't in the main briefs. The one that's most interesting is there are 3 briefs on the government side that raise a set of federalism arguments, which are, with the exception of, I guess, one paragraph or maybe a paragraph and a half in the government's brief, are absent from the government's arguments because they are arguments that, while they could help the government's position in this case, would actually compromise the government's position in a lot of other contexts, including some other pending Affordable Care Act cases. And that relates to just how we construe statutes that alter the balance of federal and state power. And those are interesting arguments. They're arguments I actually think, that I have some sympathy for, but they're ones that are very dangerous for the federal government because whether it's this law, whether it's No Child Left Behind, and whether it's the Clean Air Act, if you place that much weight on these federalism doctrines in this case, you have effect across the U.S. Code. In terms of the standing issue, standing is a serious issue. Lower courts considered standing in these cases. The federal government, in all of the cases raising this issue, left no stone unturned in trying to find jurisdictional ways to make these cases either go away or to slow them down. I find it hard to believe that if the federal government thought it could challenge the standing of all 4 plaintiffs, which is what it would have to do, that it wouldn't raise that. I just again, observing everything they've done up to this point, I don't know why they wouldn't do it. One of the reasons when one is bringing a case like this that you have multiple plaintiffs is that it takes a year, 2, 3 years to get a case resolved, and if your claim on standing is based on current year income or next year's anticipated income, you don't have a lot of control over that, and so you have multiple plaintiffs precisely because things may change. Now, there's actually a legal argument that those sorts of year-to-year income changes actually shouldn't deprive the court of jurisdiction because there are, I'm trying to think of a nice quick way to say it, there are doctrines that deal with the fact that there are types of legal questions that are moving targets if you have to maintain the same position throughout the course of litigation. But even setting that aside, the attorneys for the plaintiffs say that they believe they still have standing, and I don't see any reason why. I don't see any reason to doubt that. And again, if the government thinks it had a shot at this, I can't imagine they wouldn't take it, and they haven't yet.
Other questions? Going once? Going twice? Please join me in thanking our panelists.